And we are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host. I'm in DC today. I actually received something and you're soon going to learn about it. And it's because of you all. And I want to thank you. And soon I'll be able to share that news with you. But something quite special in this fight that we've endured together. Today's topic is simply going to answer some questions because I just did a link to fireside chat and I felt bad because I was told there were lots of questions, but we had to end. And so I figured we'd come back live, do that, and then pick it up next week. All right. With that said, let's take the first question. Is the SEC streamlining platforms like Prometheum? Listen, the Prometheum thing, and that's what I'm going to call it, is one of the most suspicious things I've ever seen as far as regulation. How Prometheum became this, got registered with the SEC in the middle of this crypto war is not a coincidence. And I tweeted out before a picture of a vending machine, and the vending machine was empty. That is the Promethean business model as it exists today, that they can sell some crypto digital asset securities, but they can't even sell Bitcoin. They can't sell Ethereum. They can't sell anything. All it was a show, in my opinion. Promethean went from April of 2021 as saying how we needed new regulation and we needed Congress to act, to all of a sudden being a Democratic witness at hearings saying, oh no, look what we did. Coinbase and Kraken and all the other businesses, they're the bad guys. It is very simple. We did it. It was a plant. And I believe that, and I'll believe it until it's proven otherwise. So yes, the SEC streamlined them for political reasons. Next question. What is holding back the pump on XRP? Well, everybody knows that's watching that John Deaton is not a financial market advisor. If you could look at my portfolio, you would know that I am no genius at timing the market. But I did say that, with that said, that Bitcoin drives this market. I tweeted that out. I also said before the XRP ruling that unless we're in a bull market with Bitcoin first leading the way, I never believed that XRP was going to break its all-time high. I did think it would go above $1, but that's just me, individual investor, no more better or sophisticated than you at picking stocks or picking crypto. But Bitcoin will lead the way, and then I believe XRP will actually outdo Bitcoin and ETH. That's my personal opinion. Please never invest based on my personal opinions, okay? Because then you're going to have a very red looking portfolio like I do right now. Okay, next question. If Judge Torres denies the SEC interlocutory appeal, is settlement more likely? As long as the Coinbase case is pending, and the SEC is in this anti-crypto agenda, I don't believe that they can agree to a settlement. I know they don't want to go to trial against Brad Garlinghouse and Chris Larson because they're never going to prove that case. They're never going to prove recklessness. Understand that? Again, just so everybody knows that if Judge Rakoff, this is where we can use Judge Rakoff's opinion. If Judge Rakoff if the SEC in their last pleading said, look, these two sophisticated judges have a disagreement about something, about whether or not, crypto sold on exchanges can be securities, investment contracts. Well, if these two sophisticated judges are conflicted, how the hell is Brad Garlinghouse and Chris Larson going to be reckless in not knowing XRP was a security? So the SEC doesn't want to settle that case. I believe Judge Torres is going to deny the interlocutory appeal. And then I think that depending on what happens in the Coinbase case is going to dictate whether there's a settlement. As long as they're going after Coinbase and claiming that those 11 or 12 tokens are securities, how do they settle with XRP and Ripple? They can, but it's very difficult. You should assume that it's not going to happen. Next question. Can the government be sued for not going after ETH? The answer is no, not based on the way that you phrased the question. Selective enforcement is not a basis to go after, right? Here's the best example that I can give everyone. Remember, the question is, can we sue the SEC for not going after ETH, for not prosecuting ETH founders? And the answer is a resounding no. Bernie Madoff is the best example. The SEC was told multiple times that Bernie Madoff was running a Ponzi scheme. And there was evidence presented to the SEC like 5 times. Look, he's stealing people's money. It's a fraud. And the SEC did nothing. The SEC prosecuted Bernie Madoff after Bernie Madoff confessed. And a bunch of investors who lost money from Bernie Madoff, they sued the SEC. And they sued the SEC saying, look at that gross negligence by the SEC. We should be compensated. That's a pretty good argument one could make, right? Because trust me, we can all admit that the SEC intentionally turned a blind eye, if you will, to Bernie Madoff. Bernie Madoff was on the short list to become SEC chairman. That's how effed up our system has become. But that case of Bernie Madoff investors suing the SEC was dismissed because the SEC is part of the executive branch. And it's up to the executive to make what's called discretionary decisions about who to sue and who not to sue. And a court can't then, because of separation of powers and things like that, can't go in and say, hey, you should have did this, you should have did that, if it involves discretion. And so those cases were dismissed. Now, that doesn't mean that there can't be a case against individuals who used to be regulators and other individuals if you can prove a conspiracy to provide a regulatory advantage, a monopoly, so to speak. If you can prove that kind of evidence, then you can possibly get over the hurdle. So that's the answer. And we really need to push for that investigation into the decision of the speech and everything that went down, because I'm confident that there is enough evidence to potentially get past some of those hurdles. So you got to stand by. Next question. Can Ripple sell XRP directly abroad without U.S. legal problems after the Torres decision? Well, Ripple could sell XRP abroad before the Torres decision. So the answer to your question is yes, but there's a Supreme Court case called Morrison, which basically requires, in order for the SEC to have jurisdiction over a sale of a potential security, it has to be within the United States of America. That's the SEC. SEC governs the United States. So one of the major defenses that Ripple always had was that 95% of their sales are outside of the United States. Therefore, the SEC doesn't have jurisdiction. When you think about Japan, the United Kingdom, Singapore, United Arab Emirates, Switzerland, and other jurisdictions that have declared, their regulatory agency has declared that XRP is not a security. So if Ripple or Brad Garlinghouse or anyone else sells XRP in Japan and it's not a security, how could that ever be considered illegal? So that's why also Ripple has been able to keep hiring during this crypto winter and been able to increase their market share, if you will, overseas because of that ability to sell XRP regardless of its regulatory status outside of the United States. Okay, next question. Can XRP holders sue Hinman and Clayton? Well, it's sort of related to that question that I answered already. You can't sue them for their discretionary functions because they have what's called qualified immunity and sovereign immunity. Think of a police officer. A police officer, you can sue if they do intentional things, if there's malice involved, if there's evidence of some kind of criminal activity. But if a police officer arrests you and they're just negligent, like they don't have probable cause, for example, they think they do, but they don't, and they falsely arrest you, you can sue the government, but you can't sue the cops individually because they would have what's called qualified immunity. They were acting within the scope of their duties and they didn't do anything intentional. And so a lot depends on evidence. Is there evidence that we can show that gets over the hurdle of immunity? I can tell you that Brad Garley, and there's also a standing issue. We'd have to be able to prove that we have standing to sue them. And that gets into a lot of complex legal issues, foreseeability, all kinds of things that I don't have time to get into right now. But I will tell you, when you think of standing, if there's a case against them, certainly Ripple, Brad Garlinghouse, Chris Larson would have the most standing to bring a potential case if you can prove that there was a civil conspiracy to conspire to give a regulatory advantage to one group of small investors and punish another group. So there we go. Next question. Did I get the steak dinner from Charlie Gasparino yet? And the answer is no. Now, in all fairness, I have been on the road. I haven't been in New York. I went on vacation. I was in London with my daughters and in Portugal. I'm in DC. I'm going to Texas. But the answer is no. I do expect to collect one day, but I haven't collected yet. Does the SEC have unlimited money? How long can they? Well, that's why the SEC is good at one thing. The SEC is good at crushing new startups and innovation, because a small group of entrepreneurs, if they do fundraise, they raise funds, and let's say they raise those funds legally, most people can't say, well, we raised $10 million, but we need to save half of it for legal fees to fight the SEC. The SEC has a budget over $2 billion. I don't know how much the enforcement is, but Gary Gensler just went to the Congress and he says, give me more money. He even said, I'm doubling down on my crypto enforcement. I'm expanding the crypto unit. He's already expanded it twice. And because they have your and my taxpayer money. And so they use that and then they prosecute. And so they're also hiring lawyers. And so they do have unlimited sources when compared to small entrepreneurs. One of the things, ironically, a lot of people wanted Ripple to be prosecuted because of Ripple's pre-mine and all those things. And I say it is a blessing in disguise that Ripple was chosen. I know Ripple may feel differently. I know Brad and Chris may feel differently. But when you're looking at the crypto industry in general, it's a blessing, because how many other entities out there could withstand $100 to $200 million in legal fees? All right, just the discovery alone. And that's, the mistake, I guess, the SEC, they picked someone who was A, willing to fight back, and B, had the resources to fund the fight. If you don't have the money, you can't fight. And that's just the reality. And I've learned, because I've spoken to these entrepreneurs, and library, Jeremy Kaufman is a perfect example. Jeremy Kaufman told me that he spent a couple $1 million in legal fees before the lawsuit. and they threatened to bankrupt him, if you remember all that. Then they filed a lawsuit after several years of investigation, and then you need to come up with another $5 million. And how many companies can do that? And so, but what we've learned is when you punch back, when you fight back, the SEC is not that great at fighting when you fight back. And we've demonstrated that. Next question. Do you think Coinbase will win its case, or are the tokens named in that case dead if the SEC wins? Well, remember, when you ask the question, will Coinbase win? My answer is yes. I believe Coinbase is going to win. But remember, there's different stages of the litigation. The big question right now is, what is the judge going to do with the motion to dismiss? And there are very smart lawyers out there who are handicapping that the judge might very well dismiss the Coinbase case. And just imagine if the judge were to take a similar position of what Judge Torres wrote. And let's say the judge says, you know what, as a matter of law, since Coinbase is not the issuer of these tokens, and since Coinbase, it's a blind bid-ask transaction, the buyer does not know the seller. If you do not know the seller, you cannot rely on the efforts of the seller. As a matter of law, this is just not a securities transaction. It is an asset that is traded on an exchange in a blind bid and ask. She could say that about the tokens. The earn part of the Coinbase lawsuit, where there's some staking, that's a little bit more complicated. So what I'm dying to know is, will this judge say, split the baby at the motion to dismiss, if you will, and say, hey, these token sales are not securities as a matter of law, but the SEC can move forward in their case as it relates to staking, or maybe she gives the Coinbase an outright win. So that's the motion to dismiss. If most motions to dismiss are denied, and then you move on to discovery, and you move on to the depositions, and you move on to the summary judgment arguments and motions and all of that stuff. And so I can't tell you whether or not the judge is going to grant the motion to dismiss. I think the chances are better than some people out there think. But ultimately, when all the dust settles, Coinbase is going to win. Does the ruling that XRP itself is not a security kneecap the SEC on the whole crypto market? No, the answer to that is no, because it's really frustrating for me that we had to get a ruling that XRP itself is not a security. It's the one thing that I fought for the very most. I had an entire section in the amicus brief that said the token itself is never the security. But the SEC was taking this shortcut approach and just saying the tokens are securities. Any asset can be sold, marketed, packaged, offered as an investment contract. That's why we bring up beavers have been actually packaged. The actual beavers, the animals, have been packaged as an investment contract. Bitcoin was packaged in 2013 as a security. Gold could be, gold contracts. Anything can be. Chinchillas, orange groves, So no, it doesn't handicap, because it's the sell, it's the offer and the sell of the assets that's the issue. But what it does do is it took the wind, the political wind out of the sails, if you will, or the political sails of the SEC, because they kept saying the tokens are securities. Gary Gensler kept saying most of these except Bitcoin are securities, and you can't say that. You can't say that anymore. And so now we have the SEC conceding in paperwork and in pleadings that the token itself is not a security. They lie and claim they never said that. which is bullshit. If they had never said that, I wouldn't be on crypto law right now because I never got involved and I wouldn't have had to have 75,000 of my friends join me. And so you out there helped make sure that we took that wind out of their sails. Okay, next question. Chip from On the Chain. What up, Chip? Did you like the badass shit as coffee? Yes, I did. Absolutely. Appreciate you, appreciate Eddie, appreciate everybody out there that has been so supportive. I got chocolates not too long ago. My waistline's not very happy about it, but thank you. All right, next question. Do we have another one? We got about 5 minutes. Can the judge award costs to defendants if the SEC loses these cases? The answer is the judge could. It's very rare. Usually in America, our system of justice, each side pays for their lawyers, right? Whether you win or you lose. In England and other places, winner gets their fees as well. Now, some cases like breach of contract cases or punitive cases, but in a case where the SEC says, hey, we have this theory that you sold a security on this particular transaction and the SEC loses, that's not so much. There are times when the SEC could be ordered to pay for certain costs. And that happened in the Ripple case where the SEC caused Ripple to have extra fees that they shouldn't have. And the SEC had to pay for some of Ripple's expert fees or things of that nature. But overall, each side pays. The theory, just for you out there want to know why that is, the theory in America is that if you take it to a winner take all kind of scenario, then people won't push cases. If they have to file a case, it could be civil liberties case. It could be, something that's very important. But if you lose and you have to pay millions of fees because you lost, you are less likely to bring cases that maybe you should bring. And so that's the theory behind our system. What's next? Why have Jed McCaleb and Joe Lubin been left alone by the SEC? Well, those are two very different questions. And I would not group Jed McCaleb and Joe Lubin together only because Joe Lubin wasn't left alone. He was an active participant, as far as I'm concerned, with the SEC. We had Jay Clayton going to Bill Hinman saying, hey, can you hook up Sullivan and Cromwell? They represent Consensus and Lubin. And then we know that Bill Hinman reached out to Joe Lubin and set up a meeting and then had 4 to 6 more meetings within 6 months. That's almost a meeting a month. Okay. We know that from the Hinman emails that Joe Lubin set up a meeting between Vitalik and Bill Hinman. And so they weren't left alone. They were active participants. Go on Crypto Law's video library and you see Joe Lubin out there talking about how great the SEC is, how they're getting it right, how they're not going to give any more regulatory clarity to any other token than Bitcoin and Ethereum. We have his friend Mike Novogratz predicting 6 days before the speech exactly what would happen in the speech. So there's some people, they can deny it all they want, but they had inside knowledge. Now, why Jed McCaleb was left off, and I have nothing against Jed McCaleb. I personally think that Jed McCaleb would be on the Mount Rushmore of crypto, right? You'd have Satoshi and you'd have Vitalik and you'd have Jed McCaleb. Why? Well, Jed McCaleb is responsible. He was a Bitcoin developer. He was involved with Mt. Gox. He started the XRP ledger and XRP, and then he went on with XLM. So I'm not saying anything bad against the guy, but here's a fact. I stick to facts. And facts are that during the lawsuit, from the day the lawsuit was filed against Ripple, Brad Garlinghouse, and Chris Larson, until the lawsuit ended, The SEC was seeking $1.3 billion from Ripple, Brad, and Chris. Yet during that period of time, Jed McCaleb sold $2.6 billion, twice what the SEC was seeking against Ripple and its executives of XRP. He sold that during the pendency of the lawsuit. And I bring that up only because it proves that the SEC is full of shit. If XRP was a security and all cells were securities, then why are they letting the co-founder sell twice as much as the company damages are seeking against the company for the same type of cells? And so it just shows you the flaw. Now, there's theories that Jed may have cooperated. How did the SEC get the two lawyer agreements, the two lawyer letters in 2012? Who knows? I don't know. I'm not going to speculate. All I can tell you is that I think Jed McCaleb is the true Don, Teflon Don of crypto, because he was associated with Mt. Gox and he walked away. He was associated clearly with XRP and the XRP ledger, and he escaped. And XLM is a mirror copy of XRP, and they've always been able to continue to do business and never be brought into any of these suits. And so your guess is as good as mine. Okay, I'll take one more question and then we got to end it for the day. I got to catch a plane, go see my baby girl. What's up? What do we got? How can young people educate themselves to follow in your footsteps? Well, thank you for the implication of that. All I can say is not have the attitude. Everything's about perspective and attitude. When I started this writ of mandamus and I sued the SEC, you can't worry about the naysayers. You have to put the FUD out. People said, you'll never make a difference, John. You're going to lose. You're going to lose. And remember, there were times I stumbled, because we all stumble. And, the judge denied something here or there. And I said, okay, well, just pick yourself up and you get up again. And eventually you keep fighting and trying to make a difference. And then what you do is you inspire other people. And that inspired 75,000 people to join. And when those 75,000 people joined, it inspired me way more than you could ever imagine. And we made a difference. It's not me speculating. It's in the decision, right? The two things that we were involved in both got cited in the decision. So that you have to adopt an attitude that even when it's unpopular, even when you're going to be laughed at, even when you're going to be called wild conspiracy theory guy, when you're going to be laughed at by your colleagues, you say, I'm going to do the right thing, no matter what the cost, no matter what other people say, and you stick to it, and you can make a difference. And we did make a difference. And I love you guys out there, and I'll see you next week.